Cell USLLS, deem it as my privilege to be able to welcome you all for this exciting session today. Let me start by introducing our college. University School of Law and Legal Studies was established in 2001 and has acquired the distinct status of an institution of eminence in the legal field, with an objective to serve in this field with advanced education. USLLS is also in an advantageous position as it is situated in the vicinity of the Supreme Court, Delhi High Court, various subordinate courts, and commissions. We have been ranked 12th in the NIRF rankings by the Ministry of Education in 2021. Moving over, I would also like to give a brief introduction of the ADR Cell, University School of Law and Legal Studies. Founded in 2020, the ADR Cell is a faculty-cum student-run forum that endeavors to foster and instill a vibrant culture of ADR amongst the student community. We at the ADR Cell aim by these meaningful engagement with industry experts, such as this conference today, to be able to imbibe cutting-edge ideas and thoughts in the field of ADR. Moving on, I would humbly like to invite our faculty supervisor, Dr. Zubair Ahmed Khan, to please deliver the welcome address.
Thank you, Mike. A very good evening to all the respected dignitaries present here and all the participants of the second day event. This is our value-added program on resolving disputes in the metaverse. And on behalf of Law School in ADR Cell, we wholeheartedly welcome you. First of all, I'd like to say thanks to my Dean, Professor Amarpal Singh, and my faculty colleague and the coordinator of the ADR Cell, Dr. Vandana Singh, who helped all of us in organizing this event. And today, we are going to discuss a number of contemporary issues with regard to future of dispute resolution in the metaverse. So I welcome Mr. Rishabh Malivaji. I also welcome Mr. Gaurav Malhotra ji, Mr. Kreguta Leonia, if I pronounce correctly, and Mr. Sahil also, Ms. Ritika, and Mr. Tejas also. There have been different topics on which we're going to have brainstorming sessions with regard to NFT regulations and the dispute issues with respect to dispute resolutions in the metaverse. So I welcome all of you without wasting time. I ask Mayank to initiate the program also. Mayank.
Thank you, sir. And with that, I would also like to thank our event partners, that is Singapore International Arbitration Center and Careers in Arbitration, for making this event possible. I would like to introduce our inaugural speaker, Mr. Rishabh Malviya. Mr. Rishabh Malviya is a Deputy Counsel at Singapore International Arbitration Center, where he is involved in the administration of arbitration cases. Prior to joining SIAC, Rishabh sir was based in Mumbai and worked in the disputes team of one of the largest law firms in India. His practice in India focused on commercial arbitration, domestic and international, and litigation across various industries and fora. Mr. Rishabh is qualified to practice law in India and holds an LLM degree in international arbitration and dispute resolution from the National University of Singapore. Mr. Rishabh joins us today to speak on the topic, that is future of dispute resolution platforms in the metaverse. Over to you, sir.
Thank you so much, Mayank. Thank you, Dr. Khan, for the introduction and for the invitation. I'm very excited to be here, so many thanks for having me. Personally, I think one of the most important skills that one must acquire as a lawyer, and as I'm finding out as I go along in my career, is the ability and in fact the willingness to upskill oneself, right, in a world that is changing at an almost breakneck speed. So it's great that student-led events like this are forcing people, including me, to think about the metaverse and Web 3.0, which is, I think, going to be a great disruptor, and the legal industry will have to respond to the new challenges that are thrown up. So, and I think what we're doing here today and this conference is a great start to that. It's a great first step towards getting there. So my topic for today, like Mayank mentioned, is the future of dispute resolution platforms in the metaverse. So I realize that some of this may have been covered yesterday at the conference for those of you who attended it, but I wanted to kick things off today by talking briefly about the types of disputes that may be thrown up in relation to the metaverse. So forgive any overlap that there may be, but it's probably a good way to start off today and set the agenda for today. So what type of disputes can we expect to see in relation to the metaverse, and what sort of disputes are we in fact already seeing in relation to the metaverse and Web 3.0? So firstly, of course, is the simple, or rather the simpler contractual disputes, right? So it's the disputes between the parties to the transaction, which in some cases may be a smart contract. So for example, a buyer did not receive the exact specifications in the product that the buyer paid for. So insofar as the crypto or the consideration is deposited in what we understand more colloquially as an escrow system in the smart contract, the buyer may want to withdraw the funds, or the seller may want to receive the funds. So any dispute resolution mechanism will need to determine where the money should go, right? So that's one kind of dispute, and maybe a simpler form of dispute that we may see. Then, of course, there are disputes with the developers of the smart contracts themselves, right? Now, the contracts as we understand them today are basically usually drafted by lawyers or by business persons, and they're expressed in natural language, the languages that we all speak. But smart contracts will basically be expressed in code. Now, what happens is sometimes there may be bugs in this code, and this may lead to losses to parties to the smart contract. And this is not something that is abstract. It's happened, from what I understand, a few months ago. There was an NFT launch called Akuter, and the sales proceeds of that got locked into the smart contract, and nobody got the money, right? So this leads to interesting questions in relation to the allocation of risk, right? And the proper parties to the dispute. So was the developer responsible? To what extent was the developer responsible? Does the developer have any fiduciary duties to the parties? So this is a new kind of dispute that we may see going forward. Right, then there's of course the crypto-related disputes, and we're already beginning to see some of those, including at institutions such as at the SIAC. So you'll see disputes related to the ownership of cryptocurrencies or the validity of disbursement of cryptocurrencies, for example, after the initial coin offerings that take place. Now, such disputes, of course, because of the very different nature of the disputes, they may require one very quick dispute resolution. A lot of the parties may be anonymous. You may need injunctions to prevent cryptocurrencies being alienated in situations where courts perhaps don't even recognize the legal status of cryptocurrencies. So things are changing, and you will see more disputes related to cryptocurrencies as well. Then, of course, you have the NFT related disputes. I think Sahil and Ritika will cover those a bit more later today. But just to sort of introduce those, what we're seeing so far is, and quite often, is disputes related to how intellectual properties apply in relation to NFTs and in the metaverse. One famous example is that of the Quentin Tarantino dispute, where he created an NFT in relation to the script of the movie Pulp Fiction, right? And he sold those. The production studio sued him for infringement of their copyright, because they own the copyright to that script. But the contract, which was drafted in 1994, obviously could not have contemplated something like an NFT. So as you can see, there are various kinds of disputes which are, and it's sort of changing, it's ever evolving. And there may be obviously different kinds of disputes that we've not covered. Another one is virtual real estate, which personally I don't fully understand yet. People are essentially investing in virtual real estate in the metaverse. What that means is they're buying plots of lands in the metaverse. Now, ownership as we currently understand it in the real world is your right in rem. Essentially, it's recognized by a perpetual entity like the state. And if you own a piece of land, it's a right against the world. In the metaverse context, effectively, from what I understand, the right is effectively recognized by a private organization, which is the metaverse platform, right? So what if you have disputes with that platform? What if they shut down? What if they go bankrupt? What if they stop you from using their platform, right? So these are all sort of questions that will have to be resolved going forward. And perhaps nobody has an answer yet, but we'll see as we go along. And this is not again, it's not something that we haven't seen before. Some of you may know of the platform called Second Life. It was almost like a precursor to the metaverse. It was a very rudimentary form of the metaverse where you could build an avatar and sort of live a second life on the internet. What happened is sometime in 2013, the studio that hosted that Second Life platform, they canceled the membership of certain users of the platform, because of which they lost out on certain plots of land and their rights in relation to those user accounts. Of course, that case got settled eventually, so nothing really came of it, but we have seen disputes like that in the past. So the dispute resolution going forward and the modes of dispute resolution going forward will sort of have to evolve and respond to these new kinds of challenges that are being thrown up. So what are the kinds of dispute resolution that we may see? One, of course, is the on-chain dispute resolution mechanisms, or the blockchain dispute resolution mechanisms, right? So my understanding currently is that smart contracts are limited to simpler contractual rights. For example, in relation to money, or in relation to the ownership under the contract, right? So in simpler disputes, such as in relation to simple payment or simple transfer of ownership, the enforcement or the execution of a decision may be possible on chain, right? So which means that on the blockchain itself. What this means is that the smart contract allows for the automatic credit of, say, the money in relation to the transaction, or automatic transfer of ownership. So in such cases, you may see dispute resolution mechanisms that are structured on chain, that is, they may follow a certain blockchain protocol, which means effectively that the dispute resolution mechanism is also coded into the contract. Now, what are these dispute resolution mechanisms? Effectively, there's some form or variation of online arbitration, if you use the term very, very loosely. The dispute resolution protocols will dictate standards for the adjudicators or the jurors, the forms of the decision and the procedures that are to be employed in arriving at that decision. One example is the Kleros platform. Now, it's described, and they describe it as a decentralized court system which allows for arbitration of smart contracts by crowdsourced jurors, right? So I'll just sort of explain how it works. Firstly, anyone can become a juror, that is an adjudicator. The jurors are then financially incentivized to come to the best possible conclusion. And how does this financial incentive work? So the jurors are asked to stake some crypto to participate as jurors. If they vote with the majority of the other jurors, they earn some crypto. And if they vote in the minority on the dispute, then they lose what they have staked, right? Appeals are also possible in this mechanism. I think you just add more and more jurors as you go along, so the fees increases, so they're sort of discouraged. So to put it more simply, a dispute arises. Willing people are selected at random to act as judges. The judges must take some crypto. Basically, they must bet that crypto. The judges then vote on the dispute, whether there is liability or no liability, along with sometimes very brief justifications for that vote. If you vote in the majority, then you earn some crypto. And if you vote in the minority, you lose that crypto. Another example is Aragon, which functions largely in a similar manner. I think there are 7 or 8 other similar sort of dispute resolution protocols, but they all work largely in a similar manner from what I can see. So now effectively it's humans deciding the matter. They vote a particular way. They enter the vote on the blockchain, which can then be executed by a smart contract. Now in theory, it's a complete departure from the traditional modes of enforcement, and the decision is enforced almost automatically without reference to a court, right? But what this also means is that this form of dispute resolution may be effective only when you don't actually need to go to court for enforcement. Essentially, only disputes, or the simpler disputes, where the decision can be enforced on chain. And there's lots of potential issues with such dispute resolution mechanisms, at least in terms that we understand today. So firstly, the decisions are largely unreasoned, right? So we have no way to ensure whether the jurors have voted in a consistent manner, whether there is even any rationale for their vote. They could be voting completely randomly. There's no way to know whether the limited evidence that can be submitted in such procedures has been examined by the jurors. Reasons, if they're given, they're very brief. This obviously leads to due process concerns, which in turn leads to problems with any enforcement that you may want off the chain. That is, if you ever want to go to court to enforce any such decision. There's also probably issues with the independence of the arbitrators or the jurors. And the system relies on anonymity to try to ensure independence. Essentially, you don't know who the jurors are, so they should be independent, and the jurors don't know who you are, so they should be independent. However, ultimately, it's like a small group of tech-savvy individuals who are acting as jurors. There's no guarantee that the decision will be coherent or independent. Again, like I mentioned, there's also limited scope for submitting evidence in these procedures. Firstly, there's no way to compel evidence. There's at least as of now, there is no way that you can go to court and get the court to compel people to submit evidence, which you can do in the traditional modes of dispute resolution. There's also no scope for witness examination, expert examination, cross-examination, or any of that. So again, it may not be suited to the slightly more complex disputes that we may see, and that we do see, in fact. Again, now largely also these sort of procedures rely on what is known as the game theory, which basically means that if people have the right financial incentive, they will act in a reasonable and consistent manner. So as you can see, these dispute resolution mechanisms are based on that. The edifice of the system is that almost anyone can become an adjudicator. Adjudicators will vote coherently if they have the right financial incentives, and any decision by the majority will in fact be coherent. I think for me personally, this is based on too many assumptions. Firstly, there's, like I said, there's no way to know whether they are actually voting coherently or not. Also, there is no reason that a decision by the majority will in fact be coherent or reasonable. I don't think humans are so predictable. We've seen humans, especially on the internet, and when they are granted anonymity, acting in completely random manners, which are not consistent with psychological principles or even market principles like game theory. I think those of you who were on Twitter or Reddit last year will know the whole saga about Reddit users and Wall Street. So I'll just tell you what happened there. Now, what happened there is that Wall Street was effectively shorting the stocks of a company called GameStop. Basically, they were betting against those stocks, and they were betting that those stocks would fall. Reddit users found out about it, and just to take down Wall Street, and in complete defiance of common sense, they started buying up those stocks, which meant that the prices went up and Wall Street started losing money. Now, there was no rationale for doing that except that Reddit users could do it, so they did do it. So that's sort of how humans behave when they are anonymous and when they're on the internet. So I don't know whether the game theory is is a very sound basis to base your dispute resolution mechanisms on. So those are some of the concerns I have with some of the dispute resolution mechanisms that are coming up. And what this means is that the traditional modes of dispute resolution, I think, will continue to have a role to play. So while there may be a change in the underlying subject matter, I think the traditional proceedings, as we understand them, whether they may be arbitration or mediation or even the court system, are probably robust enough to remain relevant, especially the more complex rights under contracts. And the more complex contracts will continue to be governed by natural language contracts and not smart contracts, or perhaps some form of hybrid between natural language contracts and smart contracts. Moreover, a lot of the disputes, including the ones that we started off discussing at the beginning of the session, will probably require off-chain enforcement, that is enforcement using state machinery. And for that, I think the traditional modes of dispute resolution will remain relevant. We've already seen arbitration has evolved over the years. Even courts are responding, including to the new kinds of disputes that are being thrown up. We've seen courts, including courts in Singapore, for example, that have dealt with crypto-related disputes and will continue to do so. Courts, especially even in London, are responding to this quite well. And Of course, international arbitration as a concept has a lot of advantages for these new kind of disputes. Firstly, as we all know, the New York Convention ensures international enforceability of awards in over 170 countries now, I think. So it's perfectly suited for these kind of disputes, which are likely to be transnational or borderless or span many jurisdictions, right? These proceedings can also be confidential by and large, arbitration proceedings, that is, or even mediation proceedings. You can also ensure to some extent expertise in these proceedings, including that of your decision makers, because you get to choose your arbitrators. You can ensure that they're people who are well versed with these kind of new concepts. And you'll also have a greater degree of control over the process, especially in arbitration. And also, if you look at several institutional rules, including the SIAC rules, you'll see that specialized procedures that have been developed by these institutions will be very, very relevant to such disputes. One example of that is the emergency arbitration procedure. The emergency arbitration procedure sort of helps you to get interim relief before an arbitral tribunal is constituted. You can get relief over weekends. You can get relief essentially in a few days after you raise a dispute. Similar is the expedited procedure that you will find under some rules, including the SIAC rules, where you can get a final award in around 6 months. So that's why I think that the traditional modes of dispute resolution will continue to remain relevant. But what I see happening is perhaps an evolution in these traditional modes, as I call them, of dispute resolution. Firstly, you may see more specialized rules emerging. You're already seeing this, at least in a rudimentary way, with the digital dispute resolution rules that have been released by the UK Jurisdiction Task Force. Now, by and large, these rules are consistent with the arbitral rules that we presently understand. They're not a dramatic departure from those, but what they ensure is, for example, that the timelines are quite quick. They ensure that parties can choose to be confidential, for example, if they want to. They allow for processes whereby arbitrators can sort of enforce decisions directly if the smart contract allows for it. They also recognize procedures where there can be automatic dispute resolution, including by artificial intelligence. So you may see more specialized rules like this emerging. One way that we need to evolve, of course, is to develop a deeper expertise. I think people will need training. Like I said at the beginning, this sort of session is a good start towards that. People in the legal industry will need to respond, will need to train, will need to develop these sort of skills for the new disputes. And another thing we'll likely see is hybrid enforcement solutions. Now, you may very well see real world decisions being enforced on the blockchain. For example, an arbitral award may, once it is issued, you may need it to be enforced on a blockchain. So arbitrators may be allowed to key in the decision and sort of trigger the sort of protocol that is needed under the smart contract. Conversely, you may also see, and that may be more, or that may be less forthcoming and may take some more time, is you may see blockchain related or on-chain dispute resolution mechanisms, the outcomes of those being enforced in the real world. I think we've seen a bit of that from the Mexican court's decision in relation to the Kleros arbitration award. What happened is that a human arbitrator drafted a procedural order, sent it to Kleros. Kleros followed its dispute resolution mechanism, came up with an outcome. The outcome was then reduced to writing by the arbitrator in the award, and the Mexican courts allowed enforcement of that award. So you may see more such hybrid enforcement solutions. And then, of course, there's the general use cases of blockchain itself, or the blockchain technology itself in dispute resolution mechanisms. And I think Garv will cover a bit of that a little later. So that's how I see the modes of dispute resolution evolving in the future. That's why I see dispute resolution heading in relation to these kind of disputes. And I note that I'm just about out of time, so I'll hand it over to the experts now to take this forward on the topics that they've been assigned. So thank you very much, and I'll be around for the discussion.
Thank you, sir, for secondly giving us an insight into the future of dispute resolution mechanisms, and even after how they may still evolve to become completely independent and in the metaverse, they may still have to be there may still have to be enforcement done through the human world, through the physical world. And on that note, I would like to invite our first speaker on the expert panel, which is Mr. Garth Malhotra. And I would like to take this opportunity to introduce our speaker. So, Mr. Malhotra is an international disputes lawyer and Indian litigator who deals with a wide range of matters relating to international goods and services, construction of buildings, vessels, highways, dams, disruptive technologies, aviations, and other sectors. He is also experienced in conducting matters for individuals, companies, and state-owned entities in matters involving Indian, Singapore, and English laws under SIAC, International Chamber of Commerce, UNCITRAL, United Nations Commission of International Trade Law, etc. Mr. Malhotra received his Law and Commerce degree from Gujarat National Law University and has also graduated with the Glass Scholarship with a Glass Scholarship and a master's degree in International Dispute Resolution from CIDS, Geneva Center for International Dispute Settlement, and the University of Geneva, and has a second master's degree in International Arbitration from the National University of Singapore. He is also read at the Hague Academy of International Law, Academy de Detroit International de La Hague. And I would like to uh, invite Mr. Garg to speak on the topic that is Metaverse and the status of DAO. Sorry, resolving disputes better in the Metaverse, blockchain, and disruptive technologies. Please, sir.
Hi, everyone. Hello, ladies and gentlemen. Thank you for being here. I'm grateful to the organizers for putting together this event, especially to Mayank, and also grateful to SIAC and Careers in Arbitration for supporting this. We live in great times. For the first time in human history of about 2 million years, we can be so far apart and yet communicate almost as if we are in the same room. And I hope you can hear and see me clearly. And this has happened only in a span of a few years. Now, this transformation is a very recent phenomenon. And let me just quickly share my screen and put up the PowerPoint here. Yeah, and to put things into perspective, the first email was sent in 1971. And in 1991, the first ever website went online, and this is what it looked like. It's just some text with a bunch of hyperlinks. And fast forward a few years, we have now billions of people surfing the internet. We have YouTubers with audiences larger than media houses. We have robots which can backflip and also play chess and break fingers while they're at it. That's the Boston Dynamics Atlas, one of my favorite humanoid robots. And, we live in great times. Today, technology is moving at a rate much faster than any of us had imagined before. Metaverse, blockchain, artificial intelligence, and machine learning. These are all disruptive technologies of our era, which have the potential to transform law, business, practice, and the whole world as we know it practically. And they're called disruptive technologies because of their ability to disrupt the status quo. Now, my topic today is how these technologies will shape the future of dispute resolution, how blockchain, AI, metaverse will make dispute resolution the way we practice it right now into a much more efficient mechanism. But talking about these technologies is actually a very normative exercise. Imagine a panel in the 1990s talking about how mobile apps will change our life and how the kind of impact mobile apps will have on our life. And this is exactly the kind of speculation that I'm doing here. trying to gaze into the crystal ball and imagine a future where disruptive technologies can make the whole process more efficient. And so whatever we speculate here may turn out to be accurate, but might just as well turn out to be a source of humorous reflection a few years later. And, as a disputes lawyer, I can completely understand why we need to embrace modern technology. As a tech enthusiast, I can see a number of areas where a magical synergy can be formed between technology and the law. But as a pragmatic realist, we need to be circumspect, and thus I am skeptically bullish on the future of these synergies, because I can foresee a number of hoops that we will have to jump through before we reach a stage where we can efficiently use technology in order to improve our dispute resolution process. And with these caveats out of the way, I will divide the rest of what I'm going to say in 4 parts. I will start with the why. I'll start with the why. The reasons why we need to embrace these modern cutting edge technologies which can really enhance the dispute resolution process. Why do we need them? I'll discuss a few possible areas of synergy between law and specific technologies like blockchain, artificial intelligence and machine learning, and the metaverse. I'll then look at a few challenges that require our urgent attention, and end quickly with 3 recommendations for the shared future of law and technology. Now, I'm a lawyer whose practice usually focuses on arbitration and international business laws. And that's why I will try to specifically focus on things out of my own experience. My experience lies in representing companies and advising companies mostly in the infrastructure and technology driven sectors. And I've also had the chance to act for clients in court litigations in a number of Asian countries. And most of my assessment of this field is based from these experiences, as well as my own conversations with clients and friends who are very involved with these areas. Now, long story short, if we look at our modern dispute resolution systems, I think that they have become archaic and inefficient. It takes way too long and costs way too much to resolve a dispute. And yet, even when you win the battles, very often you are finding yourself in a situation where everybody is dissatisfied with the outcome and disillusioned with the process altogether. Our physical world capabilities of resolving disputes have been stretched to their maximum capacity. We never envisaged these kinds and these volumes of disputes, at least when it comes to court infrastructure, and very often even in arbitration, which is why, despite the mushrooming of arbitration institutions, practically all the institutions are thriving in one niche or another. Now, judicial pendency is hitting an all-time high, and faith in the justice system is at an all-time low. And that's just because the whole system is plagued with a lot of inefficiencies. But if we look at technology generally, we can see in the last few years a number of areas which were traditionally plagued with issues of efficiency and also accessibility have now become streamlined and accessible because of technology. Take a simple example of Uber. Now, just in a few short years, we now have the luxury of all of us having personal drivers on call, something which was a luxury just a few years ago. And with all of this in perspective, I think we are on the cusp of a paradigm shift in terms of law practice and the world as we know it. And there are a lot of things in the whole dispute resolution process that can be optimized and made much more efficient with the use of the modern technologies that we are now seeing. Now, while there can be a number of possibilities, I can't even list here where law and technology can be fused together for an efficient result. And the technologies that we can use to build a brighter future for dispute resolution. I think the three key areas that deserve their special mention are artificial intelligence and machine learning, blockchain and smart contracts, and the metaverse. And so allow me to quickly look at each of these. And AI-based algorithms have the potential of changing the world as it exists. And I'm very confident that in the next few decades at least, AI-based algorithms will impact a lot of our life, very often without us realizing it. Now, if we specifically look at some of their applications to the legal sector, it really can do a lot of good. For instance, very often we see in-house teams, especially in the construction sector, struggling with the volumes of documentation and getting their documents right, making the right objections with the right people at the right time, something which often requires you to check engineering data, check your contractual data, and then put it into the mechanism for seeing an arbitration later at the stage. And so AI, once trained properly, can really help streamline that process. Even when it comes to our own research, when we research and draft documents and advise clients, AI assistants can really help us with a lot of things. And a few years ago, I did a dispute where just the document volumes were unmanageable. And we had like 64 boxes of like double-sided ring binders in a dispute where the strategy was bury the other side in paperwork. And we got the client to convince to give us access to this software called Relativity, which was an AI-driven document management and segregation software. And we used it, and it was fantastic, at least for that particular case. And when you use technologies like this firsthand, you realize the immense potential that they have for impacting the way we do our normal dispute resolution process these days. And I am not personally of the view that AI will replace lawyers, but very often I believe that lawyers who use AI assistance will replace lawyers who do not. And we see this in historical examples, like when we talk about online research. When it had initially come, there would have been resistance to it and things like that. But still, we see today that virtually everybody has adopted that technology, and it has made us much more efficient. Now, I also think that AI has the possibility of completely replacing transcribers and translators. And we see this progressively more and more in our daily practice. Google Translate has been doing fantastically in the last few years because of machine learning, and even softwares that we use. For instance, we commonly use a software called Otter, which I think it would have been much easier if I had discovered in law school. So if you haven't, maybe you should check it out. And these are transcription softwares which have now become very accurate and progressively become much more accurate. Now, I also think that it will improve the administration of disputes by institutions as well as court registries. You see, court registries are very often overworked, and there is a lot of redundancies and efficiency issues, especially when we are filing matters with courts. Now, if we move to blockchain and smart contracts, we are just scratching the surface. We barely know what it can accomplish. We think it can accomplish a lot of things, but we do need to have some skepticism as well as some pragmatic approach towards these new technologies without just rushing into them without thinking them through. Now, obviously, blockchain has very often it gives us proof of things which are hard to alter. And that gives us the ability to verify authenticity of things, especially like digital evidences. Fake videos and deep fakes have become a real problem that our times are dealing with. And so things like blockchain can help us in that direction in verification of the authenticity. You can even envisage a future where you can have assets, at least record of assets of companies on a blockchain, which makes it easier for us to trace assets and have enforcement mechanisms which are spread across the world. Even they can help automate some rudimentary and mechanical parts of the contracting process. I personally am not I do not think that smart contracts, at least in the foreseeable future, are here to replace normal contracts as we know them today. But there are parts which can be automated, which has to be distinguished from AI. Automation and AI are very different things. And so there's a lot of scope in that direction as well. Now, if you look at the third thing, Metaverse. Now, Metaverse can provide an experiential alternative to virtual hearings. And, we all got used to doing virtual hearings in the pandemic, but even if you give me a choice today, I would prefer a physical hearing over the virtual hearing. And that's just because I prefer 3D over 2D, perhaps, because 2D feels impersonal, and the experience of interacting with somebody is just not replicated when we are looking at somebody on the screen. Having said this, we all agree that virtual hearings is very often much better than no hearings at all. And any advancement in virtual hearings is likely to bring us closer to the experience of physical hearings. If we could all have access to Maxwell chambers, despite which part of the world that we are sitting in. Similarly, in terms of education, I was thinking that, yesterday evening I was having a chat with one of our colleagues in the panel, and I was telling her that how awesome would it be if not just you can see us, but we could see you in a lifelike simulation sitting in front like audience. I could look left and right, and I could see Rishabh and Sahil sitting next to me. Even in simulation, it would perhaps be a very enjoyable experience. And things like problems of location and space, central location, the amount of space we need to accomplish a lot of things, that can be solved using these parallel universes. But I think despite the fanfare, I think we need to be very circumspect and very practical about how long it will take us to get there. There are many challenges right across the corner, which are not just legal and technological challenges, but sociological challenges. And personally, I think one of the biggest challenges that we have is the issue of overpromise and under-delivery. We've been hearing about cyborg soldiers and self-driven cars for a very long time now. But it's still a long road before we are comfortable sitting at the backseat of our car with no one at the wheel. And thus, even once the technology exists, we are far from reaching a stage where we are comfortable using it, right? And that's also true with business. The other day, I was talking to one of my fairly sophisticated clients who's very well equipped and abreast with the technological developments. And I was trying to explain to her the concept of smart contracts. I told her about the trigger-based automation that can be programmed into contracts and create self-executing mechanisms. And her baffling questions were, okay, so now I don't just need a lawyer to have my contracts, I also need a coder. And things like, what about the coder's attorney-client privilege? And what happens if I need to interpret the contract and dispute the other side's interpretation? Do I need to do it in code? How does that work? Who can understand it? And these are very practical problems, which we will continue to discover the closer we get to employing these technologies together. And issues on the technical side also are things that we need to consider from a legal standpoint. Like, what data sets we use to train our AI. How do we go about collecting the data and processing the data? What are the benchmarks we use? What is the accuracy level of the AI that we are comfortable with? Things like, how do we regulate synthetic data to train AI, and how do we account for issues of undersampling and bias? And these are things that not very often come to the forefront once a technology is ready. And so we need to already think about them at this stage. And how these things can impact an AI-driven process. A very commonly shared anecdote is that of the Amazon AI, which was training on how to select CVs from a pool of candidates, and based on historical data that it was training on. And because of the inherent biases in the data that it was using, it reached a stage where the AI was automatically discarding all women candidates. And that's because, and started only selecting a particular stereotype of candidates because the data itself had inherent bias, which the machine taught itself. The machine is learning from the data that we give it. And so what data we give it, how do we regulate that? All of these are very key challenges. And for those interested in looking at the speed at which these things are going, you can just follow the chess related examples of AlphaGo and Stockfish and all of these programs, which will show you the tremendous analytical and computational power that AI can have and how quickly it can learn. But what do we do when the AI does inexplicable things? Things you just cannot explain. For instance, media reports show something very disturbing last week in Russia, in a tournament of Moscow Open. This 7-year-old child was playing against a robot. And you see in this very low resolution picture that after a point, the robot mistakes the kid's finger as a chess piece and goes ahead to just break the finger of a child. And these are practical problems that we don't really know how to deal with. So what do we do when the AI does inexplicable things? Now, there are a lot of other things that we still haven't figured out. For instance, what do we do about issues of privacy, cybersecurity, property rights? Yesterday, the stellar speaker from 39SX, Mr. Neeraj, was speaking about the cases that the English High Court have dealt with as property. But one, very fragmented jurisprudence exists. And two, we are very often trying to draw parallels with things that we understand, with theft and chattels and things like that. But what do we do when we are completely in uncharted territory? And while technocrats may have answers to all of these questions, like they can say AI can be programmed theoretically in such a way that neutral metrics are adopted and we can discount bias, I think the biggest problem will be getting consensus on what constitutes bias. And that's a much harder practical challenge. And so we need to draw our own lines in finding common consensus. In sum, I think there's a lot of work that needs to be done. There is a magical synergy that is waiting for us, but a lot of work has to be done in getting there. And perhaps technology, like always, will advance much faster than law and policy can keep up. And so for us, despite there being an efficient technology which exists, its deployment is going to be a conscious choice, which will have to, in some ways, involve consensus. And the key question for our times will be, where do we draw the line rather than what technology exists? And so in this background, I think I would want to conclude with 3 recommendations, which I think are useful for the shared golden future of law and technology. First, I think we need substantial investment of time and resources in understanding the efficiency advantages that technology, when fused with the legal process, can offer, as well as the policy challenges that it may throw up. And such efforts are very essential so that when we reach the stage that we are ready to legislate on these things, we shouldn't start the research and policy implications from zero. The lawmakers already have a head start. Second, and I think it's very important for especially young people and people taking initiative like Mayank, for instance, to listen, that we need law schools to collaborate with engineering schools to set up dedicated labs and accelerator programs which focus on legal technology. And this will enable us to experiment and explore different areas where technology and law can be fused for an efficient result. And last, I think as a society, we need to be circumspect about what parts of the legal process are we comfortable delegating to technology. We cannot just look at technology as the magic pill, which will solve all the inefficiencies and redundancies in our system right now. We cannot rely on the benevolence of either people or technology. Rishabh touched upon that. I think the latest video of an AI robot breaking the opponent's finger is again one more thing which makes us realize we cannot even rely on the benevolence of technology. And we have to be skeptic and a little conservative in where we draw our own lines. That's it. Thank you so much for your patience. I'm very excited and looking forward to what the other panelists have to say.
Thanks a lot, sir. I think your presentation was an eye-opener for everyone, because you may have painted a rosy picture of how Metaverse and dispute resolution platforms may look like, but you have indeed pointed out the inherent risks and challenges. But indeed, being able to adopt a shared vision and approach would indeed benefit us in accelerating this change. And with that, I would like to invite our second speaker on the expert panel, Professor Krenguta Lua. Ms. Krenguta is a professor of new technologies, law, comparative alternative dispute resolution law, and business law at the Faculty of Cybernetics, Informatics, and Statistics for Economy at Faculty of Law, Faculty of Accountancy and Management, Information Systems, and Faculty of Law at, at the University of Bucharest. Ma'am is also the visiting scholar at Columbia University in the city of New York and a guest lecturer at Georgetown University, Arizona State University in Phoenix, and Florida International University in Miami, and Sciences Po in Paris. Ms. Krenguta also holds a PhD degree from the Bucharest University of Economic Studies. She also practices law as a counsel and an arbitrator and participates in international interdisciplinary complex problem-solving teams. She is a past vice president of the International Court of Arbitration of the International Chamber of Commerce, ICC Paris, and she is currently a member of the board of directors of the Silicon Valley Arbitration and Mediation Center. We invite Ms. Krenguta Lua to speak on the topic, that is, Metaverse and the status of decentralized autonomous organization and the resolution of disputes pertaining to DAO through ADR techniques. Ma'am, over to you.
Thank you very much for the kind invitation and also the opportunity to address you on this very, very challenging topic, because in the history of blockchain, DAOs are the new creatures. These are the new developments, because what actually we have seen as alternatives to the previously existing structures in the world of money through cryptocurrency, and later on in the world of finances through DeFi, and later on in the world of communication through this kind of blend between internet and the game industry, and the real world interactions created by the metaverse. Now we see in the world of organizations. DAOs are the, if you want, revolution of organizational structures. It's very interesting to look at what exactly the very acronym mean. DAO means decentralized, or stands for decentralized autonomous organization. Decentralized refers to the distribution of power and resources. So there is no specific majority that can unilaterally decide in the hands of one individual. In this sense, DAO's governance is rather heterarchical rather than hierarchical. So we look at an organization that is flat and not pyramidal in terms of decisions. Autonomous represents the independence from human interference. So it doesn't mean that actually each individual is completely autonomous. It simply means that there is no need for human interference to enable the process and to maintain the relationships in the DAO. This organization basically submits as a proposal to their members a reform of the way in which they are governed, so for the relationships to be, in this sense, autonomous, to be automated in the form of smart contracts. And then what organization means in the sense of DAO? Well, here we are looking at a very basic definition of what an organization is. Basically, a group of people that are sharing a joint mission. It's not that there will be very easy then to include this kind of organizations into the typical ones that are regulated by law. What happened with these structures, with this organization of people, is that they actually try to enter into a territory which previously was the monopoly of the states, which sort of decided which are the kind of structures that we may have if we want to build an organization. And that was for the purpose of recognizing legal personality to these organizations. And because that was a monopoly of the state to decide who other than one individual, namely a group of individuals, can be treated as one individual in the form of a legal personality. Because of that, the states decided what kind of legal entities we may have. And that was some centuries ago already. Since then, we evolved very little. So we saw very little revolution, if you want, as a concept of profound transformation of the world of corporate structures. Both in terms of, if you look at the corporate structures as profit, for-profit corporations, or non-profit associations, foundations, or other type of non-profit like trade unions, for instance. Their structure is decided by law. Each country decided which are the main features of the governance of this kind of entities, decided what is required in order for these organizations to be registered and awarded legal personality, and also decided what are the main public order provisions that the organization of these entities cannot avoid, and therefore they cannot deviate from that in their bylaws. For that reason, the whole world of corporate structures, of non-profit organization, the whole world of organizations is a world that it is heavily regulated in the physical world in which we are living in. And not only that it is heavily regulated, it is very territorial. Because we can all remember, those that are, we work in international arbitration, that usually in most of the international private law choices, it is the law of incorporation that governs everything related with the capacity and the structure of a legal person. So for that reason, it was very interesting to see what happened in the blockchain ecosystem in the moment when this kind of organization started to develop. Basically, what they tried, the initiators of this kind of organizations, it was basically to find an alternative to what already was existing in the real world. And in that way, they basically focused on 4 types of features. First of all, the communication, then the pool of capital, then the vote, and then the possibility to develop projects. For each of the DAOs, it was basically a flexible contributor engagement as opposed with the normal corporate structures in which we find a fixed contributor engagement. So this contributor engagement might be flexible in terms of the projects. So some might decide to allocate their involvement into a project, some in another project, about the time contribution, about the duration, and about the compensation. So all of this became flexible. All of these are usually fixed in a company. So if I would have to compare DAOs with the traditional companies, I would say that, first of all, it is the lack of hierarchy in the decision-making that is the first characteristical element. But then also the fact that it is a certain flexibility as to the role allocation and the possibilities for the participants in the DAOs or the members in the DAOs to have a specific participation in the activities performed. Now, if you look a little bit at what is happening in the DAOs themselves, you will see that actually they have different degrees of decentralization. So it is not as flat as we might think of. Some organizations, because of their flexibility, they decide to have role allocations in which the decision is not as flat, but rather it is isolated and hierarchical in the sense that that decision has prevalence over the others. If you look at the current society in which we are living, you may see that we have a number of analogies at which we may think in terms of organization. For instance, the cooperatives. The cooperatives are organizations in which both shareholder and worker and the one who would have the benefit of the decision-making participation, the vote, belongs to the same group of people. And that is sort of resembling a little with most of the solutions that one can find in the DAO structures. So basically, when we look at DAOs, we look at alternative, innovative structure of groups and decision-making in a new type of organization. Now, this flexibility is not easy to be made compatible with the real world, with the physical world in which we are living. Why? Because states do have still the monopoly of deciding who's a legal entity and who is not. And for that reason, liability is a big problem, because if you don't fit with your DAO into the shape of a legal entity, you most likely will enjoy also the veil situation in which one, without piercing that corporate veil, will be protected from individual responsibility, and you will only have the corporate responsibility. But if you're not recognized with your DAO as a legal personality, that every single individual in the DAO will have a personal liability, joint liability normally, into as far as it concerns the decisions of the DAO and the behavior of the DAO. And the DAO is usually the organization that builds the blockchain ecosystem. It builds the smart contracts. It provides the structure on everything that the others are operating into. So for that reason, the responsibility of the members of the DAO, unless it is a corporate entity that is introducing this veil, corporate veil, it will be very, very high. And I think that at this moment, the biggest challenge that we are confronted from the perspective of potential disputes is the multiplication of disputes that we cannot even anticipate into some sort of reverse mass claims, in which you won't have a number of individuals suing one company, but you will have one individual suing millions of other individuals, which are all of them having one token into one DAO. So it will be a very, very interesting situation to deal procedurally with this kind of myriad organizations that would face disputes of such a size. It may be also that anonymity, that it is another feature of the DAOs, in the sense that once enter into the organization, the token possession provides you with the access to the vote. And for that reason, it is basically anonymous in the terms of the physical identity in real world, in the physical world, the one who votes as the owner of the token. Now, that will be a very challenging situation in terms of evidence. If one would like to file a case against a particular voter into the DAO, who is the owner of a particular token, the one that led to the decision. So I think that this type of entities, the new structures of DAOs, are one of the potentially highest sources of disputes in the future into the whole area of contractual based disputes related to the metaverse. I would like to mention a number of issues still on this topic that are related with the use of arbitration and the potential use of other alternative dispute resolution methods to address this DAO community. Maybe it's time to make you a confession. My very early days of the profession and my PhD actually is it intra-corporate disputes. So disputes between the member of organizations, in this case, between the shareholders, members of the board, everything that it is related with the internal decision-making process in a corporation. So that was my PhD. Why I made that PhD? It was because it was still a blurry area some years ago in many legislations, and arbitration in this area was always under a question mark. Still today, arbitrability of corporate disputes as intra-corporate disputes is a question mark. Not many legislations address that directly. Some do, but most of them are silent on that, while providing for the exclusive jurisdiction of the state courts for most of the corporate disputes, disputes related to the registration of a corporation, disputes related to the changes of the rights, like for instance, when somebody is excluded from a corporation, or where somebody wants to withdraw from a corporation and the bylaws of the corporation are not exactly providing this possibility as a unilateral decision, and also for all sorts of issues related to mergers and acquisitions. Why? Because normally these corporations do not have only intra-members disputes, because they have effects over third parties. So for that reason, usually the states are putting them into the category in which no arbitration agreement is possible, because the effects of whatever would be the corporate decision would be opposable to third parties, as opposed to normal contracts in which any contractual effect remains between the parties. And this opposability over third parties is a big problem in the arbitrability of certain corporate disputes. Now imagine that you would have in the DAOs an innovative way of addressing this issue. How you would do that? Well, why one actually needs a dispute resolution mechanism that it is accepted by a state? Because we need the enforcement power of the state. But if we don't need the enforcement from the state, and if we can automize the enforceability of whatever a decision would be, then in that moment, basically, we do not need for the effects of a specific decision-making process in case of a dispute to rely on the limits that are provided by the legislation of various countries. So if we are living in a world that it is beyond the need of connection with the state power in order to obtain enforcement, if we can self-enforce in the system on-chain the disputes, then we can be a little bit more flexible in terms of what kind of disputes we may solve and in which way, on-chain rather than off-chain. But the criteria is not exactly where you solve the dispute, but where you enforce it. So if you enforce it on chain, it's already, and you can automize the enforcement, then it's already a little bit more flexible. Arbitrability is not the only problem of the DAO territory. Anonymity is the biggest one, actually, because this concept of justice, whether it is public or whether it is private, it is always revolving around the concept of fairness. So we all need a fair trial in order to rely on justice. Unless the concept of fairness lacks, it will be a personal revolution. It will be we are going to react individually, all of us, against the act of justice, because justice is not a mechanism that is independent of our fundamental values. It is very much the mechanism by which we embed our fundamental value, and justice is a fundamental value. If we are going to see unjust legal systems, we are going to react over those societies. So this will happen with the blockchain ecosystems too, and it will happen in the metaverse too. If they will become unjust in the way that they provide dispute resolution, it will be a personal reaction against that. It will be a revolution, if you want, in the ecosystem against that kind of mechanism that would not provide a fair trial. And how can be a fair trial if a person doesn't know about it? How can be a decision against me if I never heard about anybody having a claim against me, and if I never been provided with the opportunity to say something on that? It will be a revolution in terms of the feelings of every single human being in the moment that such a system would be operational against the person. So for that reason, I think that anonymity, it is a problem, and it will have to be lifted in order for the decision-making concerning disputes to take place. It will have to develop at some point some sort of mechanism of revealing the person who is behind the avatar, who's behind the ownership of a token, who is behind any kind of anonymity mechanism. And to move to the final point that I wanted to make on this kind of situation is to see what kind of alternative dispute resolution we may think of, looking at what an alternative is. So far, the alternatives were very simple. We were looking at arbitrators instead of judges. We were looking at maybe online dispute resolution versus offline dispute resolution, like in person. And we were looking at decisions that are taken on the basis of the law and decisions that are taken outside the legal system, like ex aequo et bono, based on the fairness, or decisions that are based on amiabile compositor power of the arbitrators, the power of the arbitrator to do a sort of mix match of various legislations, or the possibility of the arbitrator to decide based on lex mercatoria, whose source is in the behavior of the traders and not in the legal systems and the decisions of the lawmakers of a certain country. So basically, these were the alternatives that we were confronted so far. What's happening now with the new development of the alternative dispute resolution mechanism concerning the blockchain system and the metaverse? It's happening that we are looking at alternative to this classic alternative. So we have alternative to whatever it is, an alternative dispute resolution in the classic sense at this moment. So what do we have? First of all, we do not have arbitrators instead of judges, but we may have no human decision. We may have an automated decision. We are already facing a number of cases in which we have artificial intelligence-based decision-making instead of human mind-based decision-making. And this is an algorithm that would create a specific development, I expect, for a certain type of disputes in the metaverse, because of the speed that will be needed and because of the type of organization that is also technology-based in the metaverse. So that is one thing. And the second one is the crowd justice. So instead of having one arbitrator or one judge or a limited number of arbitrators or judges, like for instance, the jury systems, we may get to crowd justice. And the crowd justice is already presented in this session of today of this conference, for instance, the Kleros system. Now, crowd justice means that you will have a large number of people that will participate into the decision making against for a specific dispute and will decide against a person or another person that are basically in dispute. I would suggest that we look very carefully at the history of humanity and look carefully what happened with the crowd justice. And remember that at least in Europe, we had Socrates' trial in which the crowd basically deprived us of one of the greatest philosophers of all time, because crowds are unjust, crowds are emotional. And crowds are easily manipulated. As we all know, a crowd justice, it's always a heavy emotional justice system. In the Middle East, we have the historical stories about the type of crowd decision as far as the biblical trial of Jesus was about. So we have examples as to how profoundly unjust crowds may be in the history, if we look at that. So I would suggest that we look carefully if we want to rebuild the systems of crowd justice and see how we can improve them if we really want to go on that path. And to move to the last point, what alternative to exequat bono, what alternative to amiabile compositor, or what alternative to lex mercatoria we may have? Well, we just heard. We have the bet. Because what Claros is doing at the time when incentivizing an arbitrator, so-called arbitrator, a decision maker, I would consider, into getting paid only if his decision will be also the decision of the majority, and having made the person losing money if he doesn't fit with the majority, it's basically deciding on the type of expectation that the majority will do. You're just betting what the majority decision will be, and you lose or you win in that bet. So we have nothing to do with law. We have nothing to do with fairness. We have nothing to do with the legal concepts at all. We don't have anything to do neither with the probability system, as an artificial intelligence would probably look at as probabilities calculations. We look only as to what is my impression that somebody else will do. Betting on the horse behavior or betting on a crowd behavior, it's no difference. So I am rather insisting in giving a very good thought at what we are doing. And I think my rather serious presentation about DAOs and the implication in the metaverse of solving disputes related to DAOs needs a little bit of explanation, and this will be my concluding remark. You know why I'm so serious anytime that I'm looking at this concept of alternative dispute resolutions for DAOs, because DAOs are the creator of the metaverse. And they have the biggest responsibility possible, because everybody else who will interact in the metaverse will do based on the type of universe they created. And my favorite analogy is with the mythology. In every single region of the world, there is a layered universe in which we have the gods, and then we have the human beings, and sometimes we have the avatars of the gods participating into the reality of this level in which we are acting as human beings. If that is the analogy that we think about, then those who build a universe in which we are right now are the standards that we have to think about when we are building universes for us to live into. So if we are going to spend part of our lives in the metaverse, we should be as responsible and following the highest standard possible, because we are going to build a world for humans to live into. Thank you.
Thank you, ma'am. I think you gave an insight as to how these creatures, as you call them, they came to be and how they actually manipulate our very interactions in the metaverse. I think that it's interesting to know that though we may want to democratize everything, but over democratization may still come back to hurt us when talking about justice dispensation. With that, I would like to move to our next speaker for the day, and that is Mr. Sahil Kanuga. Mr. Sahil Kanuga co-heads the international dispute and investigation practice at Nishit Desai Associate. He has worked on an array of complex matters, including Indian and international arbitrations, has advised on corporate and commercial laws, civil and constitutional matters, and criminal offenses. He has also negotiated private equity and joint venture transactions. He also advises multinational clients across jurisdictions on investigations involving issues such as internal fraud, anti-corruption, anti-bribery, and data privacy. Moreover, I would also like to introduce Ms. Ritika Bansal, who is a member of the International Dispute Resolution and Investigation Practice in the Nishit Desai Associate. Ritika ma'am's area of expertise includes international law and international arbitration. She has worked on numerous international commercial arbitrations seated in India, New York, Singapore, the United Kingdom, Qatar, and the United Arab Emirates. She has also worked on several investment arbitrations in the BPO sector, the real estate sector, and the oil industry. Ms. Bansal has also acted as tribunal secretary for arbitration under SIAC rules. Ma'am graduated from National School of Law, India University, and holds an LLM degree in International Business Regulation, Litigation, and Arbitration from New York University. The presentation will be led by Ritika ma'am.
Thank you so much, Mayank, for this introduction and to the entire ADR committee for hosting this conference on a very interesting and relevant topic. And also like to thank all the panelists for giving their speeches. It was really great to listen to and learn from them. So I think I just shared a presentation. So today we'll be speaking about non-fungible tokens, regulations and disputes. Just before we begin, it's important to actually understand what non-fungible tokens or NFTs are. So a non-fungible token is a digital asset that you own that records your ownership over a particular physical or digital entity on a blockchain. So it has a unique identification code. Non-fungible basically means irreplaceable. To clarify, a fungible item would be, for example, that if there is a book which was made and there are 100 copies of those books are fungible because one book can be easily replaced by the other. But now if I take a book and I add my highlights to it and I add certain comments to it, that becomes irreplaceable. So that is now non-fungible. So similarly, a non-fungible token is something which can't be replaced, and therefore it has a unique identification code which helps record your ownership over a physical or a digital entity. So to put it simply, if there is an image and I sell a non-fungible token of that image, it basically, if I buy such a non-fungible token, it records my ownership over that particular image. Now, non-fungible tokens can be proof of ownership for digital or physical entities, but usually it's easier to track the ownership of physical entities, mostly because they're not as easy to replicate identical copies of such an item. Whereas for digital entities, it's harder because there may be 100 images and copies of those images. So it becomes harder to track who actually owns such an image. And that's where NFTs become important, because that's how you can track who actually owns the true ownership of such an item. Now, NFTs are usually traded through cryptocurrencies. So to buy an NFT over a particular item, you can only do it through cryptocurrencies. The NFT market actually, so NFTs were introduced in 2014, but the market didn't actually gain that much traction. It's only in 2021 that we see that the market has really, it has ballooned, and there's been a certain level of hype around it, which wasn't there as much until now. So what blockchain was, say, 5 years back, NFTs have become that after 2021. So NFTs can be for any type of digital asset. So on one hand, we see that there is a collage of 5,000 images made by Beeple. Beeple is an artist, which for 5,000 consecutive days, he made digital art. At the end of it, he made an entire collage out of it, and he decided to sell that as an NFT, and that got sold. So an NFT could look like that, as in a digital art format. Versus there is also an NFT can also be made, for example, that Jack Dorsey made of his first ever tweet that was posted, and that was him setting up his Twitter, and that was the first ever tweet that was posted. That was also sold as an NFT. So any sort of digital asset that you didn't even know that could be sold can now be sold as NFTs. And they can be really pricey. So one of the reasons why the NFT market picked up so much hype was because these NFTs were being sold for huge, significant amounts. The 5,000 days collage was sold for $69 million. And similarly, the first ever tweet, which was posted by Jack Dorsey, was sold for $2.9 million. But it's also important to remember that the NFT market is highly volatile. So while there is a certain hype around it, like if we see that the first tweet, while it was sold for $2.9 million, the person who bought this tweet decided to then sell it further, the NFTs further. And he decided to start the bid by putting a $48 million bid. He expected that that's the amount that he will get. However, when the actual bid went through, the highest bid that he managed to get was only of $280. So this shows how NFTs is such a volatile market. And while you can maybe sell something for $69 million, it's possible that the actual value of it just ends up remaining something like $200. Now, NFTs play an important role in the metaverse. As we have discussed so far, metaverse is a virtual world, and NFTs help you own ownership of digital assets, which will be there in such a world. So as Rishabh had also previously mentioned, you can own anything in the metaverse, including things like land or cars or boats, paintings, anything. And that your ownership over those assets in a virtual world is then recorded through NFTs. That brings us to the question of how are NFTs regulated? And the simple answer is they are not. So in India, we see, as I mentioned, that NFTs can only be bought with cryptocurrencies. So we do have some regulation around cryptocurrencies, which we have seen. So for example, in 2018, the RBI issued a circular where they prevented or prohibited Indian banks from dealing in cryptocurrencies. In 2020, the Supreme Court of India actually set aside this RBI circular. They said that since there is no legislation which governs cryptocurrencies, you cannot have such any ban to this effect. Having any such ban is actually a violation of the fundamental right, which allows you to practice trade and profession. So that's Article 19(1)(g) of the Constitution. And so they set aside that circular. In 2021, the RBI issued another circular where they said that even though now the previous circular has been set aside, it's still important for banks to conduct due diligence before they engage in any cryptocurrency related transactions. The Indian Parliament recently introduced a bill which regulates cryptocurrency and digital currency. Now it's unclear. Firstly, this regulation hasn't been effected yet, so it's still in the works. Secondly, it's unclear whether this would actually cover NFTs or not. It defines cryptocurrencies to include a digital representation of value. So it can be argued that it would cover NFTs, but then this becomes questionable whether how you define NFTs to begin with. And we'll see this comparison more clearly when we come to the EU law on this. And there they have created a distinction. They have specifically mentioned and included crypto assets to mean digital representation of value or rights. Now, as I mentioned, NFT ensures that you have certain ownership over a particular asset. And that is more of in the nature of a right as compared to a value of something, or like money, for example, that can be traded for something.
I'm sensing some disturbance. Vardhan, could you mute the mic? Thank you.
Okay. But while we don't have any central regulation for NFTs yet, there are certain acts which may still be applicable to NFTs or NFT transactions. So firstly, there is the Indian Contracts Act. That would affect it because an NFT transaction is like any other smart contract transaction that you will be entering into. So when you're buying certain NFT from another buyer, you are entering into a transaction like any other contract that you'll be entering into. So that brings into questions of your other contract or contract law issues and whether there was a contract which came into effect or not. And therefore, contract law will continue to govern NFT transactions. Currently, it is questionable whether there is sufficient consideration or not. As we know, for any contract to be valid, there has to be consideration. Consideration is anything in exchange for the good or service or anything that you are contracting for. Now, as we said, cryptocurrencies is the way it's given in exchange for the NFTs. If Indian law finds that cryptocurrencies are in fact illegal, then it becomes questionable whether such a contract can be valid to begin with. Another act which would govern NFTs or would NFT transactions would be the Copyright Act. Since NFTs govern ownership of digital work, Copyright Act comes into the picture, whether who owns the copyright or not. And as we will see, most of the disputes on NFTs have been surrounding who owns copyright on a particular token or not, or on a particular piece of work, which becomes on which NFTs are sold. So therefore, Copyright Act continues to remain very relevant. There's also the income tax regulation. So in the Union Budget for 2022, they have said that there will be a flat 30% tax on any digital asset gains that people make. And they have included NFTs explicitly in this. It's interesting that they have said that while we will be taxing for such transactions, that doesn't mean that we're actually recognizing the legality of such transactions. So it's interesting while they're saying that it may not be legal, but we will still tax on any such transaction which are being made for sale of NFTs. This brings us to regulation and disputes in other countries. So for example, in the US, there is again no regulation, but there was a judgment in 1946 which defined investment contracts as money which is invested in a common enterprise where profits are expected through the effort of others. and they treat investment contracts as security. It can be argued that NFTs can be interpreted to be an investment contract, because as an investment contract, you buy NFTs with profits and you're expecting profits out of the work of someone else. And therefore, they're similar to investment contracts in this way. While it hasn't been clearly laid down by any law that NFTs are investment contracts, but it seems likely that they will be interpreted in this way by applying the Howey test. There have recently been a lot of disputes in the state of New York, especially on copyright infringement. So usually these disputes are that a particular person will sell NFTs over a particular piece of art or video or a picture, and the original owner will again sue the person who's trying to sell such NFTs, saying that they are actually there is an unauthorized sale of NFTs because this piece of work actually belongs to me that they're trying to sell. And most of these have currently been in the nature of injunctions, and the court has actually granted injunctions prohibiting such things. No similar disputes have been seen in India yet, but this has happened in the US. There are two very interesting cases which have happened this year itself in the US. One is, as Rishabh mentioned, which is the Pulp Fiction case. And as he mentioned, I'll just briefly go over the fact that Tarantino, who had actually written Pulp Fiction, he had given his rights to Miramax. And he said that Miramax can actually take the script and they have the right for production of this. Tarantino, however, had certain written versions of the script with him, and he was trying to sell pictures of those written versions as his NFT. And Miramax commenced a lawsuit against him, saying that he doesn't have ownership over that piece because he had already given those rights away to Miramax, and therefore he brought a suit against Tarantino. The question over here is more in the nature of who actually owns the copyright, because the contract through which Tarantino had given his rights to Miramax said that for print publications, Tarantino would continue to hold rights, whereas for any sort of filming, Miramax would. So the question is then based on who actually owns the copyright as compared to any NFT application of it per se. But it's interesting that it has come in the NFT sphere. The other recent dispute happened in OpenSea. So OpenSea is an NFT marketplace through which NFTs are sold. And recently, in June 2022, the US prosecutors actually began a lawsuit against one of the employees of OpenSea for engaging in insider trading, because he knew which NFTs would be sold next, and he decided to accordingly buy and sell NFTs on the platform. And therefore, a lawsuit was commenced against him for engaging in insider trading. Similarly, again, in the EU, there is no regulation currently which has been implemented on this, but there is an act which is being introduced, which is the Markets in Crypto Assets 2020 bill, which was introduced. In this, as we discussed before, they have defined crypto asset more broadly. So it is not just a digital representation of value, but also rights. So it very clearly seems to cover NFTs within an ambit. And what this law seems to achieve, it's trying to regulate strictly on how these crypto assets are actually offered to the public, or how they're sold on a trading platform, or how they're licensed. It also seeks to actually curb market abuse, which is done. So it wants to, whatever anti-competitive practices are actually engaged in, it seeks to curb that also in a crypto sphere. In the UK and the Singapore, what they have done is that rather than introducing any new regulation, they are applying their existing laws to the NFTs depending upon how that NFT is used. So if it is being used as an investment, they use their existing investment laws to it. If it's being used as money, as currency, they'll use their laws on electronic money. If it's being used as a contract, they'll use contract law for it. So very recently, what they did, the England and Wales High Court did, is they actually recognized NFTs as legal property. So in this case, a party had actually bought NFTs over a particular item, and somebody was trying to sell that item further. And they sought an injunction against the person trying to sell their asset further by claiming that they actually bought the ownership. They bought the NFTs for such property, and therefore they can't be sold by someone else. And the England and Wales High Court recognized that NFT is their own. NFT actually records the ownership of the person who bought that NFT, and therefore decided to grant an injunction from anyone else selling that property. And similarly, in a very interesting use of NFTs, they also allowed service of documents on a defendant by using NFTs. So in this case, one of the plaintiff who started a lawsuit against the defendant, they actually decided to service the documents through an NFT link. They sent a hyperlink which had the documents on a website which that hyperlink was going to, and it recorded when the defendant actually opened that link, and they counted that as proper service of documents. And that's a very interesting use of NFTs. which goes beyond just ownership over an asset, and it becomes to be used as a service token that you're actually using to service documents upon another person. So in conclusion, there is no implemented regulation anywhere which governs NFTs, but regulation is desirable because as we have seen in a lot of cases, there's sometimes where the deceased artists, other people are using the work of those artists and just selling NFTs over it. And such unfair practices which are being undertaken quite a lot recently puts the whole concept of NFT into doubt and has made a lot of artists go against the NFT movement. And therefore, having some regulation in this would make it much more desirable. In the absence of regulation, until such regulations come about, it's important that buyers exercise proper due diligence. Because what may happen is that you may buy an NFT from a person without knowing if they actually are the true owner of a product or not. And you paid that money to that person. It turns out that the true owner comes to you saying that I actually own this work and therefore you cannot own an NFT on this person because the person who sold it to you never had ownership over it. And therefore you may be held liable for copyright infringement. So in the absence of any regulation which prohibits people from doing unauthorized sale of NFTs, it's important that buyers actually do proper due diligence to buy proper NFTs from proper marketplaces or verified owners. And with that, I'll hand it back over to the area account.
Thanks a lot, ma'am. I think that you made a topic like NFT much more easier for everyone to understand. And I think that indeed all the participants would benefit from your comparative analysis of the regulations and the policies around the world. Without further ado, I would like to invite our next speaker for the day, Mr. Tejas Karya. It is my privilege to introduce Mr. Karya, who is a partner and the head of arbitration at Shardul Amarchand Mangaldas. Mr. Karya has a wide experience in handling international commercial arbitration across various sectors. Sir has also represented multinational and Indian corporations in ad hoc and institutional arbitrations seated in London, India, and Singapore. Mr. Karya regularly sits as an arbitrator and is involved and has also been involved in the drafting of amendments to the Indian Arbitration and Conciliation Act 1996. Sir is a member of SIAC Court of Arbitration and also the International Chamber of Commerce Commission on Arbitration and India. He is a fellow of the Chartered Institute of Arbitrators and director of the CIARB India branch. He is also a member of the Governing Council of the Indian Law Society. I invite Mr. Tejas Karya to speak on the topic dispute resolution in the metaverse, that is, self-governing nature of the metaverse vis-a-vis regulation by the state. Over to you, sir.
Thank you, Mayank, and thank you, ADSL, for inviting me. It's a very interesting and futuristic topic, and all of us will agree that there's not much of discussion happening on this area. And today, we have heard so many good points on DAOs and NFTs and how to resolve dispute in Metaverse. We are going to change the way we resolve dispute when we act in Metaverse, because what we do in the real world is going to change and transform into Metaverse, which we ourselves have created. And we heard Ritika saying that we need regulations. Yes, we need regulations, but regulate what? Are we going to regulate something which we can control or something which is not in our control? So the first question comes is, do we need the regulation? And if we need the regulation, who should regulate? Is it the government, the state? Which government? Is there any territoriality which would be exercised on that jurisdiction? Because every regulation can only be having a territorial applicability as far as that particular state is concerned. The extraterritorial nature of the regulation or a law is only in exceptional circumstances that the state can pass such kind of laws. So the question comes is that what is the best way to regulate these various aspects? First, let us understand what is that we are wanting to regulate. First is the new disputes, because the disputes which we are going to see in Metaverse is going to be completely different from our traditional disputes. The reason is that what we do, a buy and sell of the property or any other transaction which is going to happen in Metaverse would be a different kind of a dispute. There will be a lot of issues with regard to those new disputes. The first would be which will be the applicable law. The applicable law will be dependent on the contract between the parties, or how would you enforce? The enforceability would also be a big issue when it comes to the dispute resolution in Metaverse. What are the proper parties? Do you need any party to enforce your dispute resolution, and therefore whether you are giving a party's autonomy to resolve their dispute in an alternative way, or you would have a forced dispute resolution mechanism? Or we also discussed about DAOs, which is a unique way to resolve dispute in Metaverse. So these are the various moving parts in when it comes to Metaverse. So what we need to do is that who are the parties? The parties could be the platform itself. We represent a lot of platforms, and in India we have the Information Technology Act, which gives them the immunity from the content hosted on the platforms, so long as they perform due diligence. So there is a regulation, but that regulation has a soft touch approach and not over regulation. Would over regulation kill the entire ecosystem of Metaverse is something we have to decide. Let us see what we have right now. We have a issue with regard to the privacy, that you are maintaining privacy of the users who are putting their private information, sensitive personal information, or person information by which you can identify a natural person. Is it safe in Metaverse? So that is the first issue which we have to decide whether we need to regulate or not. Second is competition. What we need to do is, irrespective of the size of the business, we need to regulate the manner in which the business is done, and there has to be a level playing field. So to create that level playing field, we need to see the anti-competitive behavior on Metaverse. And we have existing laws in the real world where we are trying to curtail the antitrust or anti-competitive behavior, and there are heavy regulatory regimes in each country. We have seen, and India is not very far. We have a robust competitive competition law which prohibits any anti-competitive behavior or abuse of dominant position, whereby there are wide powers given to the Competition Commission of India to regulate and also correct the behavior in the sense the parties are trying to abuse their dominance or having cartel to drive out the competition. The third aspect, which is very, very important, is payments. Now, we saw that RBI tried to control the payment mechanism of crypto, and without any regulation, the court had to set it aside, because ultimately, unless and until there is a basis to regulate, it will be very difficult to control the use of cryptocurrency or NFT for that matter. And we have to really be careful when it comes to regulating the payments, because there has to be a safe and secure environment. Whenever we talk about payment, the safety and security comes to forefront, and we need to really take care of it. We have NPCI, that is National Payments Corporation of India, which is an arm of RBI, who is regulating the payment ecosystem in India. And there we have seen the contracts which are there between the banks and the service providers and various digital payment platforms. The first and foremost issue which comes is the safety of payment and trying to track the payment and protecting the consumers, because unless and until the users of Metaverse are not feeling safe, it's not going to thrive the way we want it to thrive. The fourth aspect is advertisement, because we need to regulate the way in which the people are going to make money in Metaverse. And advertisement is a big source of revenue when it comes to making money in the real world and a digital world, as well as the Metaverse. So we need to have robust mechanisms. So we have now the new Consumer Protection Act in India, which deals with the protection of consumer. There is a Consumer Protection Authority, which has wide powers to ask any kind of invest and do any kind of investigation into the interest of consumers. And ultimately, we need to see that what kind of regulations can be brought in by these authorities, whereby you can protect the consumers also in Metaverse, because we are going to see huge traffic of advertisement in metaverse, which has to be properly regulated. And if you don't, what would be the impact of that? The fifth thing is taxability. Every state wants to ensure that they get their share of the tax. It could be India, it could be any other country. Now, the problem is that the services are provided across the globe, and the companies may be headquartered in particular state, and you may have a situation where the servers are located in another jurisdiction, or it is a cloud-based storage where you don't know where the physical location of that is concerned. So for that issue, the taxability has to be linked to the physical situs of that particular service. And that is going to be a big challenge when it comes to the regulation, and the government will have to come with innovative ways of recovering the tax. And the last is the arbitrability and the arbitration disputes, which where we don't want over regulation by any particular state. Even if we see any legislation on arbitration, it only provides a framework. It leaves a lot of aspect of arbitration to the party autonomy and let the parties decide what they want to decide. So we also don't want a situation where there is a heavy regulation on the dispute resolution when it comes to the metaverse, and ultimately we have to ensure that parties have freedom to choose the mode of dispute resolution which they like to decide to resolving their dispute in metaverse. So these are the broad issues which we face when it comes to metaverse and which requires regulation. Now let us compare government regulation with self-regulation. In the history, we have seen that there are various sectors which are thriving because of self-regulation and less of government interference. It could be insurance, it could be the issues like banking, where you have the self-regulation. But there are two kinds of self-regulation. It's a pure method of self-regulation or hybrid method of self-regulation, where you don't have any role for state to play in the regulation. You have only self-regulatory bodies. These are the regulatory bodies which are funded by the industry itself. And what is the purpose of them is to control and have the code of ethics or the code of manner in which you control the entire, all the issues which are arising out of this metaverse. The idea is also to have a low entry barriers, because if you want anybody to enter metaverse, you don't want heavily regulated space where you don't know how to enter, and you need to have a level playing field where irrespective of your size, you are able to enter and conduct business in metaverse. So that is extremely important, and the self-regulatory model will really help in achieving that kind of thing. We have seen the success of self-regulating code. What every platform has to do is that they should have their own policies, and those policies really help them to control the processes which they happen on their platform. Sometimes platforms themselves are dragged into the dispute resolution, and they have to take a position either which way if they are involved in any transaction. There are now smart contracts going to come, so everything will be automated. There is issue which will come in terms of anonymization also. We heard from other speakers that that's a big risk when it comes to regulation. Even if I want to regulate my own platform through my policy, there are certain things which I'm not able to do it because of the nature of the platform itself does not allow me to do it. It's virtually impossible to verify every transaction in the real world. If you are hiding your identity or you are impersonating, it's very difficult to for the platform to identify and confirm the identity of the real user. So ultimately, we need to see that how far we can go into the self-regulation and what is the level in which we have to have the state to interfere into the regulatory mode. We need certain basic requirements for users who are in a particular state. For them to be using the metaverse, they need to be governed by the traditional laws. The law of contract is always there in every state, and ultimately we have to see then how can we extend those traditional laws to the metaverse. And if we are able to do that, we don't need to regulate metaverse in a heavy sense from by the state, and you can have a hybrid model whereby you can have self-regulatory code as far as possible, and where it fails, then you have the state regulation. So that is the ideal way to do it, rather than having a pure self-regulatory code. In fact, on privacy also, we have the judgments from the Supreme Court of India, which says that privacy is a fundamental right. And India has been toying with the idea of having this separate law on privacy, data protection. Whereas in 2008, we had an option to either create a specialist act or to amend our existing act. And we followed again an soft touch approach, whereby we went into minimalistic regulation on the privacy, included Section 43A and other sections in our Information Technology Act, rather than having a heavily regulated regime for data protection, what we have in EU. We followed the US approach of self-regulation. So we rely on the contract, and we ask the platforms and the users to go in a contractual way, but at the same time, certain due diligences have to be performed by the platform. And so long as they perform those due diligence, they are immune from any liability arising out of any action taken by the users on their platform. So those are good ways to have the regulation. But as far as NFT or payments are concerned, something which has to be regulated by the state, because self-regulation may not be sufficient, because you would have also an implication on tax. Now you have seen that we are taxing 30% on this, and there would be other aspects of indirect tax also with regard to, for in India, we have the GST regime, which whether it applies to metaverse or not, we will have to be seen, because advertisement revenue is going to be a big chunk of any activity which we do on metaverse. And that is to be seen, that where that revenue goes, and whether it has to be taxed at a particular threshold or at a particular barrier of the state, which we will have to be seen. So these are all complex issues, and we need to really ensure that whether we are able to identify these issues correctly, and whether we need state regulation or a self-regulation. In my view, in conclusion, I would like to say that metaverse has to have its own level playing field. We have to ensure that everybody is able to perform without being having any fear of safety or any intrusion on their right to privacy. Therefore, we need to have a robust self-regulatory mechanisms, and wherever there is a gap and where we see that the self-regulation may not work in a larger scheme, then only the state should step in and have the state regulation. So with that kind of approach, I feel that it would be a safe and secure environment to do business in metaverse or transact in metaverse with self-regulatory code, and have the dispute resolution which is in pure form of alternative dispute resolution. You don't have to go to court, and try to resolve the dispute through arbitration, with giving party autonomy as the as a paramount consideration for going for any alternative dispute resolution mechanism. So there should not be state regulation on that. And wherever it's only necessary, then only state should step in and try to regulate the affairs of metaverse. Thank you.
Thank you, sir. And I think it was refreshing for all the participants to understand that the extent of state regulation vis-a-vis the democratic nature of metaverse. And I would like to announce that we shall take a 5-minute break at this point. And I would also like to request our speakers to please move to the breakout room. And I would also request my colleague to help the speakers to be moved to the breakout room. In the meanwhile, I'll request Mr. Vardhan to please share the Google Form link for today's attendance, so that we're able to capture the participants who have attended today's conference. The speakers should be able to move to the breakout room by themselves. There should be an option on the left sides of the screen which says join the breakout room. Vardhan, please share the link for the attendance form for the participants.
Please don't leave the meeting. We'll start with a general moderated discussion in 2 minutes. Thank you.
Greetings, everyone. Greetings, everyone, and I welcome you all to the moderated general discussion. And I again welcome our speakers to join us in the same. I think my first question itself would be around, and any of the speakers can choose to answer this. That again, talking about how Metaverse actually works, and it can be the servers can be based in one country. It could be cloud based, and the interactions happen in no in not any kind of territorial borders. So, should we take the approach that we did with big tech, that countries have their own regulations and it is the end user experience that is regulated by the state, not the very technology, but the end user experience?
I would dare to take a view on this topic, if I may.
Indeed.
What is a peculiarity of the metaverse is that actually we are building an alternative reality in which we have options that are not open to us in the physical reality. For instance, we can embed in the software certain behavioral impossibilities. that are possible in the physical world. For instance, to harm an individual, or to take a possession that is not ours, which are possible in the real world, in the physical reality. But if you have a software that is designing the interaction between avatars in such a way in which an avatar could never produce a harm to the physical presence of the other avatar, then it will be a different situation. So where I am curious is how exactly it will be a situation in which states and countries will produce certain standards for acceptable and not acceptable behavior, and whether these standards will be simply behavioral or they will be introduced in the metaverse as restrictions embedded in code, restrictions reflected in a physical impossibility in the metaverse. So I think that at some point in time, the behavior in the metaverse will have a dual standard: the standard of the physical world outside, in which we are all there, but then also the standard that will be created by the metaverse itself, like with total freedom, partial freedom, some impossibilities, etc. I see that the protection of certain rights, like for instance of the children or other type of situations where the society is heavily concerned, might be reflected in some requirements for the corporations and the DAOs, if that would be not the case of a typical corporation, to include in the metaverse design.
And just to add, as you mentioned, Mayank, is that how do we regulate the end user experience? You have to, it's so intertwined, is that you can't just distinguish between regulating the relationship between the platform and the users and trying to say that only the end user experience. Because there are three components here: the users, the business entities, and the platform. So we need to have regulation which percolates starting from the platform, which controls the businesses, and then you will regulate the end user. End users are the beneficiaries. They should not be regulated. What you need to regulate is the business and not the end users, because ultimately whom you are protecting is the users of Metaverse, who needs regulation to protect their fundamental rights of privacy, right to property, and also being safe and secure. So that's the idea behind the regulation, and we need to ensure that it is thought through, that not only the regulation, the effectiveness of regulation and enforceability of regulation is implemented so that the technology is used to regulate. So you can't have the traditional means of regulation. You will have to also use technology to regulate technology. And unless and until we have that kind of systems in place, it will be very difficult to have the regulations which would be easily implementable in Metaverse.
Indeed. I would also like to mention that we will very much welcome questions from the audience during the course of the discussion. So you can drop them in the chat box, or you can also raise your hand and ask the questions if you wish. I think we already have a question. Mr. Harmeet, please ask your question.
Thank you, ma'am. So, first of all, greetings to this elite panel, Zubair sir and my fellow mates. So, more than a question, it's a perspective that I'd like to tell about. When we talk for metaverse, the game shifts onto the mental level. Any injury or any kind of pain that will be beared by someone who's on metaverse, who's residing in a metaverse, would be on a mental level. Now, for sure, such disputes won't be coming from a corporate shabam, but take it as a civil dispute. If someone got hit and run, not died, had some injuries, and it becomes a civil dispute in metaverse by a bike. Now, the compensation here would be done on the basis of mental injury that would have been done to the person who's injured. So, how important it is for from a legal point of view as well as a tech point of view to have devices that will be measuring that how much that will be basically measuring the mental trauma that a person has suffered and laws governing it. Thank you.
I think that's a very interesting question.
Yeah, in fact, Metaverse is complicated. He's making it more complicated by adding the mental element to it. Yeah, it's very interesting. See, the only problem is how do you prove? In any case, the in traditional world also, you are not able to prove the mental agony or the mental harassment in the civil nature. So it is has to be have some correlation with the actual loss which you suffer. And today we are in the era of mental health, and if it is going to impact anything can impact anybody who is sensitive. So you have to actually be able to prove. And so long as you are able to prove it, I'm sure there could be a way to handle the claims arising out of the mental harassment or the mental agony which you may go through due to certain breach on metaverse. So it is really difficult to prove that in the real world. So in my view, it will be slightly more difficult to prove in metaverse. Again, time will tell, but we need to build in those aspects also as we talk about regulating metaverse. But I'll be happy to hear views from other panelists as well.
I
I
agree.
think Miss Ritika Bansal, yeah, ma'am, you had something to share, I think.
Yeah, I agree. I think one feature, and this we saw from the allegation that the woman had, there was a recent case where there was a woman who got actually groped on the metaverse, and the question was that since there was no physical harm, but she suffered trauma, and whether the question is how do you regulate those situations? And one of the arguments was that since the metaverse is so all encompassing, right? Like it's not just something which is done through a screen, you are pretty much there. And the argument is that the trauma that you suffer on metaverse is quite close to something that you do suffer in the real world. It may not be completely there, but it comes quite close. So I think in those situations, again, your mental injury again is, I guess, slightly more closer to the real world. It is difficult to prove it in the real world as well, and that's the main problem, as Tejas highlighted. But I think the nature of metaverse is such that I think if you apply a standard which is very similar to the real world, it should work in most situations.
I think we have another question, which is from Mr. Ataturk Willis. So, sir, please ask away question.
Thank you for the presentations. As kind of a contribution and a question, in the last month, I'm from Istanbul, Turkey, and the fact that Istanbul IP court ruled that for the first time interim relief on an NFT, and it was a case of a Turkish rock legend who is deceased. His son filed a suit that an artist painted and sold the picture of this legend, was sued, and the court ruled that it cannot be sold or used for other purposes from this moment. And the question come to mind in Turkey that can the personal rights in a civil case interrupt with the NFT and all this kind of metaverse system? Because once a picture is drawn of a person, there's also rights behind it. But on the other hand, in order for metaverse, as the property is different, you can't own the property in your own life. I have a question in my mind. We are talking about this and reading about this in our country. What do other international people think about in their countries, the NFT, the situation and cases in their countries?
Right. I think I'll base my next question on that itself. That again, we've talked about the pulp fiction dispute. That if an NFT is formed on again a physically available product, so who would actually own the right to it? Because even taking into account the artistic expression of the same, can you actually and that too on a different I would say different horizon totally, because it does not exist in the physical world. The ownership can only be verified through the blockchain technology. Can you actually say that just because the ownership belongs to someone, the art and it contains artistic value, the physical value of the same can be ignored or it becomes diminished? So I guess I'd like to engage Mr. Garv on that.
Yeah,
because it does conflict. It does conflict.
I think a lot of what we are applying to metaverse is based on the principles that we are trying to distill from things that we understand and we already have an existing jurisprudence on. But not always is it completely applicable. And so this leaves the field open for creative argumentation. as counsels, very often when we're hearing these things, we know that there are arguments from both sides, and depending on which side we would be arguing from, we would be able to shape the argument accordingly. And that is why you cannot just leave it to councils. That's why regulation is needed, or at least we need direction from the policy perspective for a macro level. Otherwise, right now, this is an open play field for creative argumentation, and arguments can be made from both sides. Property, it's starting to be recognized. NFT, you see English court judgments, and you see across the world, NFT is starting to be recognized as property. We can clearly see the reasons and argumentation behind it. But at the same time, there are a lot of counter arguments that can be made convincingly. And so it's too early to start drawing patterns in the sand. We still need to wait and watch.
So my next question is directed to Professor Kremutaluwa, and I would just like to understand that adoption of smart contracts, because they are self-executing in nature. So do you actually think that it actually helps DAOs function more efficiently, or it creates an inherent bias, because anyways the entire process is automated and there is no human oversight? So who should be held responsible? Because there was this talk of a scam by crypto exchange, a decentralized autonomous organization. So who would actually be held responsible? For example, the self-executing contract itself is tampered with. There have been cases that the code was rerouted to accounts and the money was being sent somewhere else than it was intended to.
Well, here we will have two different levels of the discussion. First is the level of causality. What caused the problem? Where is the source of the problem? Whether the problem is in a decision taken by the DAO, or whether the problem is in a software design which has bugs as to the operation itself. So if it is a software related problem, then the user usually enters into an agreement in which the provider of the software is also providing for the guarantees and the waivers and everything that it is related with that use. So in the moment that you enter into the relationship, you are in a contractual framework that you can rely on. Now, in that contractual framework, usually you have a description as to who the parties are. And it is a little bit easier because of the terms and conditions identifying the party to decide whom actually is to be held responsible. But if it is not about a matter of software, but it is a matter of decision, that is the other side of the problem, whether a decision is taken, voted in the DAO in such a way that it affects on chain some of the relationships that are to take place related with cryptocurrency or NFTs or anything else, then it is about the responsibility for the collective decision. And this is the most interesting part, because the legislation in the physical world where we are, the typical legislation, is providing a very clear analysis as to the responsibilities of a legal personality, a corporation with a legal personality or any kind of legal entity towards third parties. And in this case, you would have the legislation telling you whether it is a corporate responsibility or it is an individual responsibility, and how that responsibility is then diffused or allocated to the one who actually took the decision in the company. And this is corporate law, basically, corporate law or the law of non-profit organizations in various countries. But if you are creating a DAO, which is innovative, then you take the whole risk of being innovative, including that of not having the back of the state legislation being clear as to which are the limits of your responsibility. And in that case, the members of the DAO, if they do not fall into a typical kind of organization, most likely will be characterized as a general partnership or even less than a general partnership, which means that if they will be jointly liable, and each of them can be sued by the person who considers that it has some rights violated by the decision in the DAO. And in that case, I think we are going to see a choice of the party who suffered harm to whom they wish to sue, and most likely they will try to sue those members of the DAO which are identified, or those members of the DAO who have the biggest patrimonial assets to have something to enforce against them. And I can see also enforcement against the tokens themselves. I mean, an enforcement against the very participation in the DAO, and some very interesting hostile takeovers taking, some models from the real world and move them into the world that we are now creating of the DAO-related metaverses.
At this point, I would just request all the participants and the speakers to please switch on their cameras so that I can request my colleague to please take a screenshot, because Mr. Karya won't be able to continue with us. He has an urgent engagement and we'll soon be getting done with the session anyways, but just for creating more memories. So I request everyone to please switch on their cameras.
Just a second.
Yes. Garrick, I think you can go ahead. Yeah. Thank you. Thank you, sir, for joining us.
Thank you. Thank you. It was a real pleasure. Thank you.
Thanks a lot, sir.
Thank you all. Bye-bye.
Thank you.
So I think I'll also wrap the session up, and one question from the moderator's side, and we have one question in the chat. So this question is directed to Mr. Rishabh. So throughout the session, we have talked about the advantages of conducting dispute resolution procedures online. It may be ODR or even in the metaverse itself, because Mr. Garg did mention that even though if you may conduct it in a virtual setting, you do not have that 3D feel. But my question is that in a process like arbitration, would you, even if you conduct it in metaverse, would it still suffice? Because the arbitrator needs to, first of all, gauge the interest of both the parties. And the arbitrators also need to be, they shouldn't be biased to any one of the parties. So to draw that line, would it be able to help if we shift the process entirely to metaverse, or do we actually allow flexibility with the same that parties get to choose their preferred methods?
Look, I think one of the biggest advantages of arbitration is the flexibility, right? And we've seen, especially post-pandemic, we've seen just how popular virtual hearings and hybrid hearings have become. So there are definite advantages to that. I think the metaverse, like Garv mentioned, also may be more immersive in that sense. And once we, of course, achieve economies of scale, and once the whole process becomes a little more cheaper and a little more accessible, I do see parties opting for this increasingly, not maybe immediately, but maybe somewhere down the line. And it definitely has advantages. And I think the disadvantages that you mentioned, that, arbitrator may not be there, we felt all of that. The arbitrator may not be there in person, may not be able to gauge the interest of parties, or may not be able to fully see how a witness is responding. We had all those concerns even pre-pandemic, right, for virtual hearings, but we sort of navigated them when they came along. And like I said, hybrid hearings, virtual hearings still remain popular, even though physical hearings have made a comeback. So I think we will see some of that going forward, even with the metaverse hearings.
And, if I may just add one quick point here, we saw the same players get into, Maxwell Chambers was doing physical hearings, and then after the pandemic stuck, Maxwell ODR became very popular. We used it and were very happy with the services, and it's very foreseeable that you see Maxwell and other entities like that come up and create their own metaverses using their experience in administration of arbitration to just make this more cost effective and accessible for everyone.
In fact, if I may just add to that, Singapore itself is examining setting up an ADR platform or a virtual dispute resolution platform in the metaverse. So people are definitely seeing the advantages of it, but we just need to wait and watch how it plays out in real terms.
And I think even with all that has been discussed over here, and I guess again I would like to thank Ms. Ritika for making us all understand what NFT finally is. Uh, and these terms have actually gained traction, and a big reason of that is the pandemic, because even our generation's interaction with the technology increased manyfold in the pandemic, and we also got to interact with these new technologies because, as Mr. Garf said, we are at the cusp of this change, and we're making progression by leaps and bounds. So I guess the final question of the day, and this is directed to both Mr. Garv and Ms. Ritika, because so one of the audience members wants to know that do you think we need a new blockchain or Web 3.0 Act in India, or should we be willing to make amendments in the IT rules, and would it suffice?
Ritika, after you, please.
Thank you. I think that to some degree, amendments in the IT acts are already there, which sort of accommodate for this to quite some degree. Like you have like written contracts, which are now being affected through smart contracts. And I think IT acts is leaps and bounds ahead in it. I do feel like we do need more regulation overall. So I don't think just IT Act is enough. So I would say that just amendments in the IT Acts are not enough, especially for NFTs. Where I feel like there needs to be some more regulation on how you go about these transactions to begin with.
I think I agree. And one problem that we've often faced in India is that our regulations are often a knee-jerk reaction to some major flare-up that happens. I think much before we need a legislation, we need Niti Aayog to set up a separate subcommittee to study this. We need students like you guys to set up collaborations and really study this, write papers on this, have research programs, and we need stellar professors like Karangota focusing their bandwidth on these topics much before we reach regulation, because we can't even have a regulation that stunts the progress of technology. That is counterproductive. But at the same time, we do need some checks and balances. And that's why I think that step one right now is to study this area much more further, dedicate time, effort, energy, and resources to understanding how it can be regulated before we actually go ahead and regulate it.
And I think that it has been amazing what all went throughout this session, because a lot of new topics were covered, and I think the speakers did do justice for us to be able to, because we've been joined by many students, and many of the students are watching us live on our YouTube. So I think that we indeed greatly benefited from this intellectual interaction. I would just like to mention for convenience of all the participants that if they'd like to check out the recording of this entire session, they can access our YouTube, and my colleague will just post the link of the YouTube channel in the chat box. I would like to humbly remind all the participants that if they haven't filled the attendance form, they can visit the link that was provided before and fill the same. And moving ahead, with the permission of Dr. Zubair Ahmed Khan, I would like to call this session to an end and go ahead with the vote of thanks. Do we have the permission, sir? Okay. So I received my faculty coordinator's permission by text. I think there is some network issue on his end. So I would once again like to thank all the speakers who joined us, that too on a Saturday, for taking out their precious time, engaging with the young generation on such cutting edge issues, which actually and that was the aim. That was our. We are joined by our faculty coordinator Vandana ma'am.
Yes, Mayank, actually,
Yes, ma'am.
it was a pleasure evening listening all the expert and the area. I must say that I was really, there were so many new things which I have heard. On behalf of USLLS and ADR Cell, again, I would like to convey my thanks to all the speakers for giving us your valuable time to our students. And certainly we will look forward for meeting physically to all of you. Thanks a lot. Thanks for coming.
Thank you for your kind words, ma'am. And indeed, I think that our aim in planning this conference itself to spark the thought-provoking discussions around this cutting-edge issue did come to fruition with the excellent presentations by these speakers. And I would once again like to thank the speakers on behalf of the ADR cell University School of Law and Legal Studies. Thanks a lot for joining, everyone.
Good night, everyone. Have a nice day.
Have a nice day.
So much.
Bye. Take care.
Thank you.